everyone. We're at week 6 of legal research, which means we're, frighteningly enough, halfway through the unit. And we are now moving into a phase of this subject where we are looking at specific research sources in some depth. So this week we are looking at rule systems, we'll look at precedent systems, we'll look at data, we'll look at theory, and basically provide some information on how to find these things and what to do with them. And these are all things that you've covered in some way before, and certainly they're things that you covered in Introduction to Law. But it's time to now have a bit of a closer look at each of these things and to make some more general observations about how those things get used in research. Beyond the fact that, these are legal authorities or these are things that you can use in research, well, how do we use them and why are they different? So this week we're starting with rules, and the most common sets of rules that we work with as lawyers is legislation. Although increasingly, regulations are more and more important and more prevalent. And this is where admin law is becoming a more crucial part of the everyday lawyer's repertoire than it used to be. It used to be that there were a few rules under important pieces of legislation, often things like traffic rules and things like that, but the majority of the work and the heavy lifting in social regulation was done by legislation. Now increasingly regulations, or what we sometimes call delegated legislation, because the legislation delegates the power to someone else to make those rules, have become the default way in which we regulate complex issues. So if you liked admin law is very important. If you didn't like admin law, that's too bad. But admin law is a very important and crucial area of law these days. The same sorts of ideas and concepts do apply though, and this is why we talk, this section is called a focus on rules, not a focus on legislation or a focus on statutes, because rule systems are very important, and even informal rule systems like policies are something that you need to navigate. And in your work life, at some point, you'll end up being someone who has to draft them and set rules, even if they're just really, mundane rules like what do we do about making sure the tea room's clean and tidy all the time? What do we do about the person who comes in and, spills mess all over the place and doesn't clean up? How do we set up a system of rules that regulates that person and make sure that they do their bit to clean up, particularly when they're making all the mess? So again, not just in legal workplaces, but an understanding of rule systems and how rule systems work become one of those key capabilities of legal graduates, and where it's very useful, where even you're working on a completely different project, completely different field, being the person who understands what's a good way to design rule systems, how to make sure they work, how to make sure that they're drafted in a simple and straightforward way, and how to make sure those rules operate within other systems of rules, really, really crucial things that we don't spend very much time on the curriculum. As you'll know, the Australian legal curriculum is still very much based on, very, very old common law approach to cases and precedent being, the focus of legal education, even though that doesn't really have a huge amount to do with what most lawyers do in their everyday life. But that being said, next week we're going to look at precedents and how they fit within the system. But fundamentally, rules are the bedrock. And even these days, there's very little common law in most areas of law. Most of it is regulated by statute. And we use the common law as a way to fill in the gaps and to understand the bits and pieces of, well, where's the specific application of this rule to a particular unusual circumstance. Then we have a look at the precedents to see if they help us out. But fundamentally, we keep a focus on the statutes. All right. So I want you to maintain a focus on rulemaking as a broader social activity, and to think about it in all those scales, from the most formal set of regulations that the tax office set up to those informal rules of, rules that parents set for kids, or, the rules of backyard cricket, what happens when someone hits the ball over the fence. and those kind of mundane, everyday, organisational things that people do, because it's all part of a continuum from very, very formal to very, very, very informal, but it's that behaviour of setting up simple sets of rules to order behaviour and using language to be able to define those rules. Now, someone who's a software programmer does very much the same thing, but uses the rules of language that a computer can understand, that the computer can, be able to act on using certain rules. We're somewhat freer because human beings are more able to understand more complex grammar than a computer, but that doesn't mean that we draft sloppy or ill-defined rules. That if we draft our rules well, they should be very, very simple and straightforward. Easier said than done in reality. So part of the focus here is a sort of a transition from moving towards simply reacting to rules and being someone who's a researcher who finds the rules, into thinking about designing and creating rules. And that has a few benefits. I mean, part of it is that these are things they're good. Being able to create rules is a very important professional skill, but also I think being able to think in that mindset helps you a lot as a researcher in using rules. That if you get to the point where you're frustrated by why is it someone who created a set of rules didn't just define them in a better way, the more you understand about the process, the more you're able to go, there's a good reason why they didn't just use the obvious word, because the obvious word might create all sorts of other side effects and other regulatory ripples that we don't want. So sometimes we've got to use odd or complex regulatory language to try and be more specific or to try and avoid an unintended consequence. And there's a big overall issue that comes into any rule system, and that's the idea of governance. And that ties us to a lot of our core beliefs about politics and our beliefs about democracy and our ideas about society as well. That ultimately, the more you think about rules, the more you have to position yourself in terms of, well, what do you think rules are about? What are the purpose of rules? What are your approach towards rules? Are you someone who is play by the letter of the rule, not the spirit of the rule? Are you someone who tries to play it as close as possible to breaking a rule? Are you someone who enjoys breaking rules and finding ways that you can get away with breaking rules without there being consequences? There's a whole lot of complicated things going on there. That's more than just saying if you set a rule, people will follow it. And there are plenty of areas of lawmaking in society where there are rules out there that basically no one follows. Or there are rules that are out there that only people follow if they're in immediate fear of getting caught. And that's communicated to them, that they know that they need to disclose something or follow a rule, and that there are consequences of what occurs. So there's a whole field in criminology around deterrence and understanding deterrence and rule-making behaviour. We're not going to cover it here, we don't really have time, but I just wanted to flag that this is part of a whole lot of an area of study and understanding for other disciplines. And you can go further with this. If this is something you're really interested in, if you're interested in everything by, how do you stop people, breaking the speed limit, all the way through to why is Monopoly such a boring game and why does no one basically finish a game of Monopoly? There's a whole series of rule and regulatory studies that you can go further in. All right, but we're not going that far today. We're drilling back to, well, how do we use them, and how do we use them as researchers? Now, the reading this week brings you back to some of the material on statutory interpretation. And you may be thinking, oh God, not statutory interpretation again. I did an intro, I did in statutory interpretation, I did advanced statutory interpretation, I'm sick of it. If you're completely over statutory interpretation, just skim the chapter. But most of us probably need a little bit of a reminder of what's involved there. And what I'm particularly interested in is the ways in which those rules help us understand the rules of construction. So it's not just a case of being passive receivers and saying, well, we apply the rules and this is the outcome that we get, but we also think about the way in which, the justum generis rule shapes the way in which a particular piece of legislation is drafted. And that means that it works in a certain way because the person drafting it knew those rules are going to be applied later on, and they knew they had to be able to make a rule that was broad enough to be able to be applied in all the situations that they foresaw, but narrow enough that it didn't create all these unseen side effects. And that is, I think that's one of the biggest fears of regulators, is creating a nonsense rule that is going to have all these sort of side effects later on. Or for some just don't care. And I'd have without getting too highly politicised, I'd have a look at some of the new rules in the United States and laws that have been passed around abortion rights, and some of the side effects some of those have had through the very strict drafting and the very strict language that's used. And there's a whole lot of things that people would have thought were unforeseen modes of regulation, of criminalising behaviour, that apparently are fine. Apparently the lawmakers are fine with over-regulating in that field. So I wanted to detach yourself from the critical aspect of whether those laws are right or wrong. I'm sure everyone has very strong opinions on that, but to really focus on these laws have all these extra effects on medical situations. Is that what the drafters of the legislation actually want? Unfortunately, sometimes it seems yes, but I think it's a good illustration of the fact that how delicate that balance is, and how there are those dangers of situations where rules drafted too broadly has an application that's not intended. Anyway, so the workshop this week, we are looking at another mapping exercise, and that's thinking around a regulatory map. And that's thinking about the ways in which different rule systems interrelate with each other and intersect. Now, in the topic that we're looking at this term, which is the committals topic, we don't have a large number of regulatory systems intersecting, but we have a couple of very formal regulatory systems around the Magistrates Court and the Supreme Court intersecting. Plus, we've got a whole lot of informal case management and organisational rules that are occurring between those organisations, police prosecution, and the Director of Prosecution's office, that also bear on this. So we'll go through the exercise in class and have a look at how some of those intersect. But I want to flag now that idea that you need to start thinking about that it's not just a case of saying what the law is on the books, because sometimes the procedural rules, the way in which different organisations work with the law and organise themselves around the law, have more to do with the effectiveness than the formal law. And those can be laws that are regulations that are reviewable under admin law, or they could just be the internal policies of an organisation that says, we do this and we do that. But those can also, you can have a perfectly good law that gets undermined because an organisation says, well, we don't apply it in that. We just don't even get into the point where we apply that law. So it's an important issue this week, but it's an important issue within a jurisdiction. These issues become vastly more complicated when you are looking cross-jurisdictional issues, and then you have multiple enforcement agencies and things interacting with each other. But it's an exercise in thinking about that mindset in terms of rule systems, regulatory objects, systems of power, and trying to take a step back, and rather than just say the law says this, thinking about, well, how are these rules related to systems, related to regulatory objects that they control, regulatory agencies that act. So it's broadening some of your skill set in terms of thinking about those things. And those things make you a much, much better lawyer at the end of the day than just simply looking up the law on the books. But of course we have to be able to do that as well. All right. So there's a little bit of guidance in the study guide on finding, locating, and reading legislation and regulations. As usual, good active reading is the core of all of this, and being able to get an overview of a set of rules first, so you know what you're looking for and how the parts of a piece of legislation work with each other, is extremely important as these rule sets get bigger and bigger and more interoperative with each other. So, as it is with many legal things, starting at the first page and starting with the first sentence and just working through it is seldom a good idea. And in some ways, the availability of legislation online, where you can go to OSLI and you can click and go to the relevant sections, is extremely helpful. But it also gets in the way of getting that big picture. In some ways, actually having the print legislation in front of you, back in the old days, where you'd open it up and you'd go to the index and you'd see how all the different pieces were related to each other, and then you'd be able to flip through and you'd be able to see those relationships. In some ways, it was easier to get a handle of a piece of legislation than something on the screen. So I'm not necessarily recommending you print out 400 pages of whatever act you're using, but I want to emphasize the fact that if what you're doing is just sort of opening the relevant section and clicking on it in OSLI, you're not giving yourself the chance or the opportunity to think about how it all works as a system. And I like to use the machine metaphor. And, a piece of legislation is a machine. It's designed to do a thing, and all the pieces are designed to work together. Sometimes they don't work together really well. Sometimes they're a bit incoherent, but you need to be able to see how the whole machine works rather than just pull out a particular section and go, okay, that section says that, and not see why it says that. And if it uses this word, is that word defined in the definition section? Is that word important for another part of the legislation where there's a whole series of descriptions of how that works or how it operates and how it fits together? So getting that systems thinking approach, getting the big systems thinking approach, is the big obstacle there, really. All right, what else have we got this week? In the equilibrium section, there's a bit of a section on the Feynman method, something I recommend to all students, which is the way to learn something is to teach someone else how to do it. And that is a very useful activity. It's why things like mentoring are very beneficial for the mentor, not just the mentee. But it also sometimes, if there's something you're having trouble getting your head around, just finding someone who is a sympathetic listener, who's not going to run away from you, and being able to say, okay, I need to be able to explain this. I need to be able to explain how the committals process works, for instance, and to sit down with 10 minutes for this poor person that you're going to beat around the ears with the description of the committals process. But that process of explaining, that process of getting it straight in your head so you can actually explain it, is a very, very useful way of getting on top of a difficult area of knowledge. So the physicist Richard Feynman was the one who first proposed it in a way that people put someone's name to it. Interesting fellow in many ways, but I certainly recommend that to you, particularly with very complicated areas of law. And don't hit the same people all the time. Don't hit your sister every time you need to explain the rule against perpetuities or estoppel or something. Spread the misery around a little bit, but in all seriousness, having someone who is willing to just go, okay, explain it to me in layman's terms, in layperson's terms, what it is that the rule against perpetuities is, will help you identify what your knowledge is, where you're lacking, and it will help things come together. All right, so the workshop this week, I don't know if I have a lot more to say about it, but it's about what would ordinarily be called systems thinking. And again, if you want to go further with this, I could really commend the whole field of systems thinking to people. It's something that not many lawyers have formal knowledge of, but it makes things make so much more sense. And certainly in terms of employability skills, being able to say, yeah, I can apply systems thinking methodology to legal problems is something which, not many people have, and it's extremely useful. And when you think about complex systems, again, always think about how informal systems operate with them as well. Lawyers do tend to sort of have this hierarchical thinking where if something's in the Constitution, it's the best thing. If it's in legislation, it's second best. If it's in regulations, it comes in bare third. And if it's a social form of regulation, well, we just don't care about it. But think about it next time you're driving or walking through not walking in traffic, but being in an area where there is traffic, think about the intersections of those rule systems. Think about, I don't think the Constitution has very much to say about traffic, but there are state legislative systems that talk about the top level stuff around rules of the road. There are criminal laws involved with if you injure someone who is on the road. These are the kind of criminal offences you can be guilty of. There's enabling legislation that creates road rules and regulations, and then you've got all the regulations around the roads as well. But it doesn't just stop there. You've got civil law systems. You've got the whole tort system that regulates how people use the roads, that regulates how insurance operates, and the way in which insurance operates informs the way in which we apply or reform the laws. A classic example is the low speed limit around schools. The reason that was brought in was because there were too many insurance claims coming through. Not really necessarily around protecting children. It was more about the crash and bash that happens around school zones in drop-off and pick-up time, and the enormous amount of pressure that insurance companies could then bring to bear on governments to say, look, change the laws to slow people down around schools. And we can just say it's about protecting children, but it's really about protecting the interest of insurance companies, and along the way we'll probably protect some children as well, so that's a good thing. But I would also think about other regulatory systems, the systems that define safety and manufacturing around cars are going to affect the traffic system, and whether things work or not. And even just like everyday systems around politeness and etiquette can make a massive difference to the way in which traffic laws operate. And there's all sorts of physical hardwired designs. And I'm kind of, I guess, a little bit of a sado regulatory nerd, looking at things like roundabouts. Why do some work and why do some not work? Why is there congestion in some and some behave smoothly? Well, parts of it are around that legal structure that sits on top of the road rules in terms of how you use a roundabout and how you indicate and who has right of way. Part of it is about how effective people are at learning and applying those rules. Because if you've got a situation where people don't understand the roundabout rules, you've got recipe for chaos anyway. But there's also a degree of etiquette and politeness and give and take in any of these systems that makes the system work better. That if you've got an environment where people are being kind of polite and observant, then you can afford to get away with rules that don't work every single time. However, if people are being aggressive or enforcing their rights to the letter under a system of rules, then you can end up a situation where the best drafted set of rules are still being thwarted by that individual behaviour. So lot to think about this week, and a lot to think about to move beyond the look up this section of the Act and this is what it is, to thinking about, well, how do we actually think about how that operates in reality, and how do we think about the way, particularly, it operates in a network of other regulatory systems, because that's where it comes to the crunch in the current world. That it's about those interrelationships of different agencies that's the cutting edge going forward, and is going to become more and more important as the world becomes more and more complex and more interjurisdictional. And that is where lawyers have their future. That even though a lot of the traditional work that lawyers have done has been absorbed by other agencies, it's been absorbed by people like conveyancers, it's been absorbed by insurance companies, we still need people who can design systems and can understand systems. And that's one of those outcomes for lawyers, that there's always going to be that need until machines can start creating their own rule systems, and then we're probably pretty much all in trouble then. Okay, I'll see you in class. I'm recording this 2 weeks ahead, but I will see you after the term break.